Welcome to this edition of Elder Care Answers. Elder Care Answers provides valuable information for senior citizens and those who love them, so we can all be more informed consumers.
Hello and welcome to Elder Care Answers, a show dedicated to finding answers to our elder care and estate planning questions. I'm Mary Ravazio, your host, and joining me is Doreen Seaman of Seaman Law Offices, whose practice focuses exclusively in elder law and estate planning. Doreen is an attorney practicing in North Central West Virginia. After witnessing the estate planning needs of friends and family, Doreen graduated from the WVU School of Law with the goal to focus on estate planning and elder law. Doreen is licensed to practice law in Pennsylvania and West Virginia, but is currently focusing on the estate planning and estate administration needs of West Virginia residents. Because it's important to Doreen to stay on top of all the latest laws and news that affect her clients, she's a member of NALA, Elder Council, and Wealth Council. These are educational and networking groups for attorneys in her area of practice, exchanging information and techniques and helping each other stay up to date on changes in the law.
That's correct, Mary. As I watch people I care about try to figure out their loved ones' finances and long-term care options, I realize this is an area of great need. I focus on estate planning and elder law, which means I create wills, trusts, and other estate planning documents to help people protect themselves and be prepared for the future.
Now, I've seen statistics in the recent newspapers, such as the Wall Street Journal, that say 70% of Americans will need some type of long-term care when they get older.
That's why it's so important that we start planning as soon as possible. The more prepared you can be, the more options for care you'll have available later in life.
So when your clients come to you, it isn't really just a one-time visit.
No, I'm helping them prepare for their future. Throughout life, people get married, have children, and retire. And for some, they might also divorce and maybe remarry or have a death in their family that affects their wishes. With each of these major life changes, it's important their estate plan continues to reflect their exact wishes.
Now, Doreen, many people think estate planning is only for older adults. Is there a certain age, for example, somebody that just turns 18 that you would recommend that's when they start organizing their estate plan?
My answer is that every adult needs at least a basic estate plan. For an example, a girl we'll call Amy. She's an 18-year-old college student. She has a bank account and possible health emergencies, and she needs medical documents and a power of attorney so her parents can help her at any time. If she has any assets in her name, she'll probably also need a will.
That's a good point. So when Amy gets married, should she include her spouse in her plan?
Yes, because if Amy had an accident and became incapacitated or even passed away, she'd want her husband to be her agent and the executor of her will. We'd also need to ensure his estate plan is in order as well.
So what happens once they have kids?
Good question, Mary. Once they have children, we'll have them nominate guardians in their powers of attorney and wills, and they'll want to provide for their children's inheritance too.
In case they are both incapacitated or deceased, would that be so the court will know who they wish to be the guardian for their kids?
Right. If the judge knows who the parents trust and would have chosen, it can be very helpful.
Now, once their kids are older, they're going to want to include them in the estate plan, right?
That's right. Once their kids are more mature, they might want them to be successor trustees, executors, and powers of attorney.
When you start working with a client, it isn't really a matter of a couple of weeks or a couple of months. I mean, you work with them for all the changes throughout life.
That's what I love about estate planning. I get to know my clients and we become like family.
That must be why you love your client care plan so much. I mean, it allows your clients to keep their estate plan up to date over time by staying in touch with each other.
Yes. For example, a client we'll call Eric and his wife signed up for our client care plan a few years ago. Over the years, his wife passed away, so Eric updated his estate plan. Then he remarried, and we included his blended family and his wishes.
So Eric has peace of mind knowing you are there for each event in life.
Yes, and I enjoy getting to know my clients and their families through all of the changes during their lives. But it isn't always family changes that bring people back for more estate planning. Sometimes it's based on changes in federal and state laws.
So do clients call you when they need to update something?
They can, or members of the client care plan can discuss any concerns with me during their periodic consultation.
Now, I know the Client Care Plan has some options, such as Secure Online Vault that stores an electronic copy of all the documents. I'm sure that's a very popular feature.
It is, and because it's safe and private, while providing the client the option to share all or a few of the documents with loved ones or others, which makes it easier when your loved ones live out of town.
They also have an option for a medical ID card, right?
Yes, it includes any health conditions and an emergency contact.
These are all great features, and you obviously care about your clients and want to take good care of them, which is why it's important for your clients to stay in touch with you.
Over the years, my clients and I get to know each other very well through our Client Care Plan, allowing me to keep their estate plan up to date. In the end, I usually assist the families with estate administration when their loved ones pass away, too.
Estate administration includes probate, and in West Virginia, it can take months or even years to complete. And I bet there's a good bit of paperwork involved, too.
Right. Probate is a public process, which is why people often choose a living trust to avoid probate. However, if a probate is needed, we're glad to help.
What can you do for someone facing a probate case?
Well, we can be as involved as the family wants. We met with a family last week who only wanted a consultation to explain the process. After that, they were comfortable to do it on their own.
But you do offer more than that.
Correct. Some families retain our services to complete the paperwork because they're worried about making a mistake. And then there are complete cases. For example, a gentleman we'll call Brian called us from Utah last month. His aunt lived here in West Virginia, and he was the executor of her will. But between his young family and new job, he doesn't feel like he can travel here for the probate process.
So you're handling the probate for him?
Exactly. Brian wants us to manage everything, including appointments at the courthouse.
If someone has a death in the family, when should they call you?
They can call when they feel comfortable. Everyone grieves differently, and we're here to help. If the executor needs to take time to be with family, it's fine to wait a few weeks to contact us.
The executor can't start the probate proceedings until he or she receives the death certificate anyway, right?
Yes. However, we find it's helpful to notify all the deceased person's sources of income as soon as possible to avoid it being improperly deposited and having to be returned.
But if someone feels like they need to be doing something, they can call you sooner?
Absolutely. If the executor wants to be prepared, we'll schedule an appointment to discuss what needs to be done as soon as possible.
So now we have a better understanding of what to expect with probate. But what benefits are available to help pay for nursing home care? Doreen will explain the ins and outs of veteran benefits and how to qualify for nursing home Medicaid when Elder Care Answers returns. Welcome back to Elder Care Answers. We mentioned earlier in the show how nearly 3/4 of Americans will need some kind of long-term care. How do you plan on paying for that? There are benefits and assistance programs available, and Doreen can help with preparing for and applying for these programs. Right, Doreen?
That's right, Mary. We help our clients reach eligibility or prepare for two benefits. First, we help people prepare or apply for nursing home Medicaid in the state of West Virginia. Second, we help eligible veterans and their families understand a benefit called the Veterans Improved Pension, or Aid in Attendance.
So let's talk about the Veterans Pension first. I always enjoy talking about a benefit for our veterans who have sacrificed so much for our country.
They have. So my team and I are always honored to work with our local wartime veterans. As part of our services, when we provide estate planning for wartime veterans, we also review whether they might qualify for the Veterans Improved Pension in the future.
That's also called Aid in Attendance, right?
Yes. The pension is for wartime veterans who are 65 years old or disabled and who served at least 90 consecutive days of active duty during specific dates of war.
If they meet that criteria and have an honorable discharge or similar designation, they can apply for that pension, right?
Well, there are other eligibility requirements as well. The person receiving the benefit is being reimbursed for money spent on medical expenses. These expenses must be for cost of care and not covered by insurance. Usually this includes things like receiving assistance with daily activities of living, such as bathing or mobility, and having an in-home caregiver.
So this pension is for veterans who have long-term medical conditions.
Right. The types of care a person needs help with have recently become more stringent, but we're always happy to review these requirements, as well as the other requirements, with our clients to help them determine if they would qualify. There are also rules about income and assets. These rules are constantly subject to change, but I work very hard to stay up to date on all and any changes.
So if a wartime veteran has a lifelong illness that requires an in-home caregiver or an assisted living facility, they should give you a call.
Yes, because my team can review all of the eligibility requirements. Now, this pension is a reimbursement to the veteran for money spent on medical care.
For example, the veteran would pay a caregiver, then receive money from the VA to cover at least some of that expense?
Yes. For veterans who need regular care that was causing a financial burden, this pension's a lifesaver. Often it can prolong someone's time at home or maybe even avoid or delay needing nursing home care.
Is this only for veterans?
No. The pension extends to surviving spouses and dependents of veterans where the veteran met the service criteria, but now the veteran's deceased.
Wow, that's a great option for veterans or widows who need assistance, but maybe not the skilled care of a nursing home yet. You also said you work with clients who are ready to apply or plan for nursing home Medicaid. Can this veteran's pension work with the costs of long-term nursing home care too?
Yes, it can, but it would not cover all of the costs. So for our wartime veterans and the rest of us, pre-planning, especially when considering long-term care costs such as nursing homes, is very important.
Nursing homes have a lot of expenses, which of course are passed along to us, the consumers. We know the cost of care in our region in West Virginia is usually somewhere between $7,000 and $10,000 a month. And as we've discussed in the past, if you can't afford to pay all of that out of your life savings or you don't have long-term care insurance, you might need to look at qualifying for Medicaid.
That's true. But to be eligible for Medicaid, an applicant who is unmarried must spend all of their assets down to $2,000, other than a couple of exempt assets such as your home, a vehicle, and life insurance policies that have very little cash value.
So some people may be thinking they don't have much, but really they do according to Medicaid rules.
Let's talk about a client we'll call Neil. He's in his early 80s, he was healthy, liked to travel and ride horses.
Well, that doesn't sound like someone who was thinking too much about long-term health care.
Unfortunately, he wasn't. But Neil fell and broke his hip while horseback riding, and after that, he's never recovered completely. Now, because of the specialized care he now requires, he lives in a nursing home in Morgantown.
Wow, that's probably not what he was expecting at all.
And because it was unexpected, he wasn't prepared. He hadn't protected any of his assets. The nursing home he lives in costs $9,000 a month.
Wow, that's $108,000 a year for the rest of his life? Most people would be broke in no time at all.
Right. Before Neil could apply for Medicaid, he had to spend down all of his life savings except $2,000 and his home to be eligible.
Well, at least then he could be eligible for Medicaid, right?
True, but sometimes we have some other issues. In this case, Neil was very hopeful that he might recuperate enough to go back to his home someday. But when you don't plan in advance, all of your income goes towards your nursing home bill, and you only have $2,000 left in savings, so it's difficult to afford insurance, taxes, and maintenance on your home.
Oh no, so what happened to Neil's home? Did he have to sell it?
In this case, fortunately, Neil's daughter could afford to help him out with those expenses. Neil hated to burden her, but it was their only choice. She was the only one who had to worry about checking on the house. She had to get the lawn mowed and all those other fun issues we deal with as homeowners.
That can be a lot of work.
Yes, and she lived out of town. She worked, and she had a family there to deal with as well.
What about if somebody doesn't have a loved one to help out with that kind of stuff?
Well, then they usually end up selling the home or just basically giving it back to the state.
So did Neil ever get well enough to return home?
Yes, he did. But don't forget that if the Medicaid recipient does eventually get well enough to go home, they've already used up their life savings prior to qualifying for Medicaid. So they're going to have trouble coming up with enough money to pay for the costs associated with the home, plus any caregivers they might need at home.
Well, this sounds really complicated. how do we keep people like Neil from essentially being prisoners in the nursing home even when they recuperate?
By planning ahead. We can help our clients get the best results by planning prior to any of these things happening. But even when somebody's already in the nursing home, there are things we can do to help them protect what assets they still have left.
Would Medicaid pay for care in the home?
Sometimes, but it's very limited, so it's not usually a solution to our dilemma.
If Neil had planned ahead, you could have worked with him to protect those assets.
Right. We were still able to protect some of the assets, which helped him return home, but we could have helped a lot more if Neil had planned at least 5 years before.
Because Medicaid has a 5-year look back?
Exactly. DHHR has a right to look back at your assets for up to 5 years. That's what we're referring to when we say there's a 5-year look back. What this means is that you can't just give away all of your assets to your kids or a trust and then apply for Medicaid without being penalized.
So what should a person do to plan for this?
They have a few options. Ideally, they work with an attorney who's knowledgeable in this area to determine what their best option is. For example, depending on their goals and what's important to them, they may choose to purchase long-term care insurance or create a trust before they're faced with this type of crisis. Others may decide to wait and see if they need long-term care. In that case, they must be willing to take the risk that they will have substantially less favorable outcome because they procrastinated. It's their choice.
Are you saying if they don't plan ahead, there's nothing you can do when they eventually need that type of care?
No. While our procrastinators won't get as good of an outcome as clients who plan ahead, we can still help them achieve a better outcome during a crisis than if they hadn't worked with us at all.
So it's never too late for you to help.
Right.
We need to take a short break, but when we come back, how do you plan for the future if you or a loved one have a disability? We'll talk about the government benefits available when Elder Care Answers continues. Welcome back to Elder Care Answers, the show that explains how to prepare for your elder care and estate planning journey. Before the break, we were talking about pre-planning for the Medicaid benefits specifically for nursing homes. Doreen, what other government benefits are available and how do you help in planning for them?
We work with people who have a disability and their loved ones to create supplemental needs or special needs trusts.
How do these special needs trusts work for somebody who has an asset-tested benefit?
They're specifically designed to enable the beneficiary who has a disability and is on asset-tested benefits to receive benefits from their special needs trust without disqualifying them from their public benefits.
Okay, so how does this work? Who provides the assets and can anybody have them?
Generally, there are two types of special needs trusts. First, let's discuss the self-settled special needs trusts, which are created with the assets of the person with the disability.
So how does that work?
Well, so a person who's on an asset-tested benefit, such as SSI, or who has assets that preclude them from qualifying from SSI, might transfer those assets to a self-settled special needs trust in order to keep or qualify for their benefits.
So maybe they had money prior to their disability or maybe inherited money and it's going to cause them to lose their SSI?
Yes. Those are both good examples of where a self-settled special needs trust might be useful. Another example would be one for a client of mine we'll call Josie. Josie was driving home from work when she was hit by a drunk driver. Due to her injuries, she'll never work again.
So is she eligible for government benefits that help with essentials like room and board? And I think I've heard that if she doesn't qualify for that, she might even lose her Medicaid insurance?
Correct. Now, the accident was completely the fault of the drunk driver. So Josie received a settlement from the insurance company.
But we know Josie would have had to spend most of the settlement money to qualify for benefits, right?
She could do that. But then what if the laws change or government runs out of funding for those disability benefits? Josie still wouldn't be able to work, but she'd also be broke. Another legal option is to create that self-settled special needs trust to hold the settlement money. That money could be used for things government benefits don't cover, and it would be there if Josie had an emergency.
Can they use the money for whatever they want?
Well, there are very complicated rules that the trustee and beneficiary must comply with, so it's important for them to get good counsel on what they may or may not spend the money on.
Okay, so that's the self-settled special needs trust. What's the other one?
The third-party special needs trusts. These are created by another person for the benefit of a person with a disability.
Such as by a parent?
It can be a parent or another loved one. The goal is to provide for the beneficiary's financial security for the rest of the beneficiary's life.
It seems that parents of a child with a disability are at their wits' end mentally and financially. So wouldn't it be difficult for them to find the time and money to create a trust?
Yes, unfortunately, we see that quite frequently. But fortunately, this type of trust can be created by others. It doesn't have to be created by the parents of the person with a disability. For example, my client will call John. He's very worried before his complimentary consultation.
He was worried about his estate plan?
He was worried about his goddaughter, Isabella, who has special needs. Her family struggles financially because of her specialized treatment expenses, and her mother doesn't work so she can care for her. So John wanted to help them.
I'm sure he wanted to plan ahead for his goddaughter. Did he use a trust?
Yes, we talked about the options and created a special needs trust for Isabella. Her family is eligible for government assistance because of the cost of her constant care and treatments.
So if John had given her money, it could have had a negative effect on the help they receive?
Yes, with a special needs trust, that money is protected for Isabella if and when she needs it without affecting her benefits. And another advantage of a trust is the ability to name successor trustees.
Why is that important?
Well, caregivers of people with disabilities often fear they'll pass away before the person for whom they're caring. Then who will take care of them? With a special needs trust, all those guidelines can be set up, giving the caregiver some peace of mind. John created the trust with himself as trustee, but if something happens to him, Isabella's parent will be the trustee, followed by her older brother.
So Isabella's funds will be managed smoothly, and Isabella is provided for over the course of her lifetime.
Exactly. A special needs trust offers so many benefits which people are unaware of, such as providing an option for a care manager.
So what's the importance of a care manager then?
Well, a care manager is usually a social worker or somebody who knows how the public benefits work and what other care a person with that type of disability might need. They stay close in touch with the beneficiary and then advise the trustee regarding what the client needs so the money is always well spent.
Now you've explained to us that anyone can create a special needs trust for another person, but can anybody contribute to the trust once it's created?
Yes. So what John started for Isabella has continued to grow as her aunts, uncles, grandparents, and even family friends contribute to the trust. This can be a labor of love from everyone who cares for Isabella. This is important because someday her parents may be living on a limited income and maybe even facing their own health care costs and issues. So it could be difficult to provide the financial and physical support that they are currently providing to Isabella. People don't usually think ahead about the child with disabilities becoming an adult or even a senior citizen someday.
See, this is why I love talking to you so much. I mean, there's more to what you do than just writing a will or creating a trust. It's your help with these benefits for veterans and for people facing nursing home care and for people with disabilities. I mean, you really offer them hope.
Thanks, Mary. I really love what I do.
So there you have it. Start preparing for your future now by giving Doreen a call at 304-554-2900. You can also visit Doreen at the website, SeamanLawOffices.com, or find Seaman Law Offices on Facebook, YouTube, or Twitter. You can request an appointment and also read the blog and find other resources that will help you with your plan. There's always new information being posted, so please stay tuned in. However you go about it, be sure to look up Doreen Seaman at Seaman Law Offices today to get your estate plan in order. And we'll see you next time on Elder Care Answers.
Welcome to this edition of Elder Care Answers. Elder Care Answers provides valuable information for senior citizens and those who love them, so we can all be more informed consumers.
Hello and welcome to Elder Care Answers, a show dedicated to finding answers